That's a good setup. Good morning, everyone. It is 9 a.m. on January 23rd. These are the hearings of the Oil Conservation Division. We've issued a docket in advance of today, but we've had a few things come in last minute, so I'm going to call a couple of cases out of order. Do we have Miss Caitlin Luck with us?
Mr. Hearing Examiner, I'm here online virtually.
Great. Can you turn your camera on?
Yeah, sure.
While we're waiting for you to do that, I see Ms. Shaheen is here with us. I'm going to call case numbers. They're not on the docket, 24977 and 24978. Entries of appearance, please.
Thank you. Good morning, Mr. Examiner, everyone. Sharon Shaheen, Santa Fe Office of Spencer Fain on behalf of Fasken Oil and Ranch.
Good morning, Ms. Shaheen.
And Caitlin Luck here this morning on behalf of Chief Capital O&G 2 LLC and WR Non-Op LLC.
Thank you. Good morning. I received a motion yesterday asking if we could continue these cases from the January 28 hearing docket. Ms. Luck, you filed that, is that correct?
Yes, that is correct.
Okay, very good. Ms. Shaheen, did you file a pre-hearing statement and exhibits as the order directed?
I did not, as I had spoken with Ms. Luck, and Fasken had agreed to continue those cases while we continue to work with Chief in Waterloo to reach a voluntary agreement.
Okay. Well, the deadline for the pre-hearing statement and the evidence in the case, your cases, passed before that motion was received. And that motion does not have enough facts for me to grant it at this time. So I'm denying that motion. And so, Ms. Shaheen, are you going to be prepared to go to hearing on next Tuesday?
We do not want to go to hearing at this point. Over the course of this, you may be aware, this is actually a third request for a continuance for these applications. There was quite a bit of time spent with BLM trying to get the drilling site approved. There was an objection to the drilling site. It has been approved, and I get my NEPA and my EAs mixed up. One of the requirements has been approved. Last week, Fasken met with BLM with respect to the NEPA process. So there's been quite a bit of delay, and during that time, there's been changes in the ownership. There have been JOAs that have expired, and there have been leases that have expired. And so the issues with Chief and Waterloo have arisen out of those issues. So that's the context there, which is why we thought it would, basically we understand now that Chief and Waterloo were not previously pooled, and the JOAs and the leases that they that relate to their interests have expired. And that is why we are now in the process of negotiating with Chief and Waterloo.
Okay, I understand the context. I understand the good cause. And Ms. Luck, I'll get to you in just a moment. But the pre-hearing order that was issued over a month ago required that you file your pre-hearing statement and your exhibits at least 4 days before the hearing, and that wasn't done. Why was that not done?
Because we had agreed with Chief and Waterloo to continue the cases. I think the rule allows us to file a motion to continue the cases, as long as that's done within 48 hours prior to the hearing date.
If you look at the order that was issued, do you have a copy of the order?
I don't have it with
Can
me
you,
now.
can you pull it up on your computer?
I
Ms. Luck, do you have a copy of the order?
see.
Yes, I do.
Okay, great. What does it say about filing for a continuance for a hearing that's scheduled? I think it's in the last paragraph.
Paragraph 8 says the request for continuance shall be filed 1 week before the hearing through the OCD fee portal.
Okay. And Ms. Shaheen, that doesn't mean it's going to be granted just because it's filed.
I understand.
Okay, so at this point, I'm not granting the continuance. So the parties will be required to appear on the 28th of January. And you have time to file a pre-hearing statement. You have time to file exhibits. I don't think Ms. Luck will object to a late filing. And what we can do is we'll go on the record, and if you need more time at that time to negotiate, at least we've got it started on Tuesday. But you can't ignore the order. You can't violate the order and expect that I'm going to grant a continuance, because I was tempted to dismiss the cases, okay, because you're not ready for the hearing. But if I dismiss the cases, you're going to be in trouble, because you're now in violation of the order if you don't have those applications in. So I'm not going to do that. So we'll call the case. So be prepared on Tuesday. I will even call it first because I have a feeling it's going to be very quick, since you're still negotiating. But in the future, I suggest that you follow these pre-hearing orders to the letter, and in the future, if you want a continuance, give me more than we need more time to negotiate, Ms. Luck. That's not enough for me. You've known about this for over a month. The parties have known about this for over a month, and to file a motion at the last minute, even if it was a week in advance, if you're still negotiating, you ought to know that you're not ready for a hearing. And Ms. Shaheen, the fact that you said that you didn't oppose the motion, it's your cases. You're asking for an amendment. It's a simple good cause hearing. So in my mind, I'm wondering, why don't you oppose it? Why are you not opposed to delaying your client's amendment? So I need more. Give me more facts so that I can base a decision on. Had this been filed timely, I would have granted it, but it's not. Is there anything else from the parties?
No, my apologies for.
Thank you. Ms. Luck?
And Mr. Hearing Examiner, apologies on our part. We were intending to file a motion related to the case due to the fact that my clients have not been pooled in these proceedings, and we believe that Fasken's pooling orders should be stayed pending any further pooling proceedings related to my client's interests. So I guess I'm just wondering if we should go ahead and file that motion now for consideration at the hearing on January 28th.
Let me think about what you're actually asking me. So this is an amendment case in that the division is looking to Fasken Oil to see whether there's good cause to grant a third extension of this. If there's another problem with the compulsory pooling order that I think you're raising now, is that you feel as though your party was not pooled and it should have been. I would think that negotiations with Ms. Shaheen would, separately from this amendment case, would require either a negotiation, or Ms. Shaheen will have to file a new compulsory pooling application to force you into a pooling order if an agreement can't be worked out. I would think that that's a separate issue, is what I'm saying.
Okay, and I just wanted clarification on that because my clients are of the opinion it's all related and that the current pooling order shouldn't be extended if they aren't pooled as required by the rules set by the division for pooling.
As far as I understand the law, Ms. Shaheen is required to show good cause. You can contest that there's not good cause. I don't know that your issue goes to good cause. You certainly can bring it up. Ms. Shaheen can object to it as not being relevant, and we'll deal with it at that time. You know, more than that, is outside the scope of what I'm here for.
Okay, thank you, Mr. Examiner.
Okay, we're off the record in those two cases. We'll hear them first, Ms. Shaheen, and I expect you to be here. Ms. Luck, I expect you to be here in Pecos Hall. We'll start at 9 a.m. on Tuesday, the 28th. And Ms. Shaheen, file your exhibits and your pre-hearing statement as soon as possible. And if Ms. Luck objects to it, we'll deal with that objection at the time.
Will do. Thank you.
We're off the record in those two cases. I'm now calling case number 1 on our docket. It is Matador Production, case 24864 and 24865.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Matador.
Thank you.
Sharon Shaheen with the Santa Fe Office of Spencer Fain on behalf of Fasken Oil and Ranch.
Good morning.
And Miguel Suazo representing XTO Energy with Beatty and Wozniak.
Thank you. Mr. Suazo, since you're not here, did you file an objection?
We did, but we've since withdrawn that objection. Okay. So at this point, we're just monitoring these proceedings, Mr. Hearing Examiner.
Thank you. Did you, when you withdrew your objection, did you file something with the division?
We did.
Thank you, sir. Ms. Vance?
Yes. So I believe it's my understanding that Matador and Fasken are in negotiations, and those negotiations are going well. And we would like to propose having another status conference in February and give the parties enough time to finish up, hopefully.
And Ms. Shaheen, you filed an objection?
Yes.
Okay.
I did.
All right. Very good. When were these cases filed?
Let me check.
Thank you.
I believe they were filed for the October hearing originally, so. I can give you the exact date. Yes, they were originally filed on September 13th.
Okay. These are getting a little old on my docket. And instead of setting them for another status conference, because if I set them for a status conference, it would be a very, very soon status conference. It wouldn't be months in advance. So I can either set them for a status conference for next month and advise the parties that if you haven't finalized your negotiations, we're going to go to a hearing relatively quickly thereafter, or we can just set it for a contested hearing in April.
We would prefer to do the status conference at this point. I think we feel good about where the negotiations are.
Okay. So the status conferences in next month are the, okay, now that's something I'm glad we're bringing this up, because next month we have the Empire Goodnight trial, basically. And I don't know, Ms. Vance, if you're going to be in that trial or not.
It depends, but we can adjust as needed.
All right. So if I'm not mistaken, the status conferences for next month will be on the 27th of February. And I think that's the week of the Empire Goodnight. Is that right, Mr. Rankin?
Yeah, that starts.
I thought so. But you have opening arguments on the 20th, don't you?
Right.
Okay. All right. So, Ms. Vance, if I set it for the 27th, I expect that you'll be here on the 27th. Now, it won't be in person. It'll be virtual.
Understood. And I did talk with Freya this morning about this exact thing. So,
All right, very good.
Yeah.
So I will set a final status conference with the emphasis on final for the 27th of February. And I will also instruct the parties, if you're not able to if you're not able to settle this, then I'm going to look at either the March 18th or the April 1st dockets for a contested hearing. So I'm going to make a note of that. So please kick those dates around to see which ones are best for your clients and their witnesses. Okay, Ms. Vance?
Understood.
Okay, very good. Ms. Shaheen?
What was the April date?
Sure, April 1st.
April 1st, April Fool's Day.
Exactly. Now, that would be a trailing docket on both days, March 18 and April 1st, but we will make time. Mr. Suazo, anything further?
No, Mr. Hearing Examiner.
Ms. Shaheen?
Not for Faskin, thank you.
All right. Well, good luck with your negotiations, Ms. Vance. And we're off the record in these two cases. I'm calling number 3 and 4 on the docket, and that is 24872, 24873, Avant Operating. Interest of appearance, please.
Good morning, Mr. Examiner. Ben Holliday on behalf of Avant Operating.
Good morning.
Good morning.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Mewburn, Apache, and Permian.
Good morning, Mr. Examiner. Jordan Kessler on behalf of EOG.
Good morning, Ms. Kessler.
Good morning, Mr. Examiner. Carrie Hatley on behalf of ConocoPhillips.
Good morning, Ms. Hadley. Okay, so which parties, so let me just ask Mr. Holliday this question. Which parties objected to these cases?
Going to look at my notes, it looks like Apache objected originally. COP objected. My understanding is, and correct me if I'm wrong, guys, the COP has the last standing objection to this case.
That's correct. I'm just monitoring for all of the parties I've entered an appearance for.
Thank you. So which party has maintained their objection at this point?
My understanding is Conoco is the party that has maintained its objection.
Ms. Hatley, is that correct?
That is correct.
It is correct. Okay. Why are you objecting?
We're trying to work an agreement, but we haven't gotten there yet. So if possible, we would like to request another status conference in February. We think we're close and we hope to resolve.
Okay, thank you, Ms. Hatley. Mr. Holliday, when did you file these two cases?
These cases were filed, I believe, in September. And the wrinkle with them is that Avant was acquired by Coterra. So it's been a bit of a, I think the parties want to work it out, but it's a bit of a who's on first in terms of who has authority to make a deal in this case. But now that sale is closed and Cimarex/Coterra owns the interest, and so I think there's a more clear path forward on it.
So
These
are
were
we
filed-
changing?
Sorry.
So are we changing the applicant in our system from Avant to Cimarex?
I don't believe so at this time.
Okay.
Yes, sir.
All right. All right, Mr. Holliday, you heard my discussion with Ms. Vance before about her September cases, how they're getting old on our books. February will be 6 months since they were filed. I understand you had an ownership change, but it is what it is. I'll set a final status conference for the February 27th docket. And it'll be virtual. You won't have any trouble attending, will you, Mr. Holliday?
No.
All right. And Ms. Hatley?
No, sir.
All right, sounds good. Please think about these dates, March 18 and April 1st for contested hearing dates if you're not able to resolve your differences, because I'm going to set it on one of those dates, and I'd like to know from the parties at that time which date is best.
Yes, sir.
All right.
Yes, sir.
Anything further, Ms. Hatley?
No, sir.
No. Mr. Holliday?
Yes, sir. Not on 7-2.
Okay, from any other party?
No.
All right, thank you. Okay, we're off the record in those two cases. Let's move on to number 5 through, there's a bunch of cases here that are all joined for hearing purposes. It looks like 5 through 10. These are Permian Resource cases 24932, 34, 35, 36, and 37 and 38. And your appearance, please.
Good morning, Mr. Examiner. Dana Hardy on behalf of Permian Resources Operating.
Good morning.
Good morning, Mr. Hearing Examiner. Darren Savage with Aberdeen Shill on behalf of Cross Timbers Energy.
Good morning.
Good morning, everyone. Dina Bennett, appearing virtually on behalf of Avant Operating.
Good morning.
Good morning, Mr. Examiner. Carrie Hatley appearing on behalf of ConocoPhillips and COG Operating.
Thank you. Okay. Ms. Hardy, which parties are currently objecting to your cases?
At this point, no one is objecting.
Oh.
Avant had objected and they withdrew their objection on January 14th. And COG had objected and just filed their notice of withdrawal of objection yesterday. So at this point, I would like to ask these cases be set on the February 13th docket for presentation by affidavit.
Okay. Now, you didn't mention Mr. Savage with Cross Timber. Did he never object?
He did not object.
He did not object. Okay. Are you just monitoring?
Yes, sir.
All right. Sounds good. So all which with objections have been withdrawn. So we will, well, you'll continue them, of course, but you'll put them on the February 13th docket for a hearing by affidavit. Okay. Is there anything else, Ms. Hardy?
No, thank you.
Okay. Anything else from any other party? Okay, thank you. We're off the record in these cases. We're moving to number 11 and 12 on our dockets. It is Mewbourne Oil, 24943. Well, wait a second. I can't. Okay, so 24943 and 24982. Answer your appearance, please.
Mr. Examiner, Jim Bruce on behalf of MRC Permian. I apologize for the mix-up on the name on the docket. Under my computer as it existed, I had to file under Mewbourne to get it timely matter.
Okay. Well, good morning, Mr. Bruce. How are you feeling?
I'm finally feeling pretty well. I might actually, I'm threatening to make an appearance at the division here pretty soon.
Okay, that's good to hear. Are there any other parties?
Good morning, Mr. Examiner. Dina Bennett, on behalf of Cimarex Energy. And I did file competing applications on behalf of Cimarex.
I didn't know that. Do you have the case numbers?
Yes, it's case numbers 25091 and 25102.
Okay, let me repeat those because your microphone is a bit muffled for some reason, so it's hard to hear you. So I'm going to repeat it. 25091, 25102.
That's correct.
All right. So Ms. Bennett, are you the only party that objected to Mr. Bruce's cases?
I'm not sure. I see Mr. Suazo is on, and I'm not sure if XTO objected or not.
Ah, very good. Thank you.
Mr. Examiner, Miguel Suazo with Beatty and Wozniak on behalf of XTO Energy. We objected to case 24943, not 24982.
All right. We have you entered in the opposite way. We have you entered as a party on 82 instead of 43. So, Brea, would you correct that?
Yes.
All right. Thank you. Okay, so Mr. Suazo, you objected to 43, but not 82. Is that right?
No, we objected, I'm sorry, to 82, not 43. So I think it's right.
Okay. All right. Freya, thank you. You don't have to correct anything. All right. So you objected. Why did you object, Mr. Suazo?
Well, my client has some issues with the development plan. It's our understanding that they've proposed U-turn drilling, which we don't think is the preferred development strategy. I know that my client's also working on a trade with another party. And so at this point, our objective in appearing is to object and hopefully get a continuance.
Okay. All right. And we have competing applications. Have you seen those competing applications, Mr. Suazo?
I have. My client's still assessing whether or not they're going to file into those cases. They have not confirmed one way or the other as of today.
Okay, very good. Okay. Mr. Bruce, when do you want to set this for a contested hearing?
That's up to you, Mr. Examiner. I did talk with Ms. Bennett and about, since those cases are not on the her cases are not on the docket until the first February hearing. We talked about having a status conference on February 27th, I believe it is, just to see if they're in the interim, if there's a way to move forward, or if we do have to have a contested hearing.
Okay. So, Ms. Bennett, any objection to your moving your cases to the, well, I guess we'll be moving your cases, Ms. Bennett, for you to the 27th of February for a status conference, and we'll join those with Mr. Bruce's cases. So, Mr. Bruce, you'll have to continue your cases 43 and 82 to the February 27th docket.
Thank you.
Okay.
Thank you, Mr. Examiner. Yes, that is what Cimarex wanted as well, is to have the cases set for a status conference on February 27th. So to the extent it matters, Cimarex agrees with that approach.
Okay,
and
sounds
prefers
good.
that approach. Thank you.
Sounds good. So at the February 27th docket, Mr. Bruce, I'll be seeking to set these for a contested hearing. So I'm going to give you a list of dates that we can set them for in April. And I'd like you and Ms. Bennett to consider the 15th of April and the 29th of April for your cases.
What was the first date, Mr. Examiner?
April 15 and April 29.
Okay, thank you.
So please consider those dates with your clients and their witness availability, because that's what I'll be looking to do in February.
Thank you.
Okay, anything else, Ms. Bennett?
Nothing from me. Thank you.
Mr. Suazo?
No, Mr. Examiner.
Okay, we're off the record in those two cases. I'm now calling Mewbourne Oil 24985. It is number 13 on our docket.
Good morning, Mr. Examiner. This is Dina Bennett, and I'm representing Texas Standard Operating New Mexico in this case. And this was a case that was filed by Mr. Bruce when he was having those computer issues, which is why it shows the applicant as Mewbourne, but the applicant is actually Texas Standard Operating New Mexico.
Okay, thank you. So it's your case, is that right, Ms. Bennett?
Yes, I filed a substitution of counsel,
Okay.
substituting myself for Mr. Bruce, and I did coordinate with Mr. Bruce before I did that.
Okay, very good. Who else do we have?
Dana Hardy
Miguel.
on behalf of BTA Oil Producers LLC.
Thank you.
And Miguel Suazo with Beatty and Wozniak on behalf of XTO Energy.
Thank you. Okay, so I wonder, Freya, is there a way to change these Mewbournes into MRC Permian for the last two cases and Texas Standard for this case?
Yes, I can change it. It may not transfer to this type of report for a spreadsheet, but I'll play around with it.
Okay, good, thank you. Because it's confusing when the applicant's name is wrong. Okay, Mr. Suazo, did you object?
Yes, we did object on the grounds that we didn't receive AFEs with sufficient time to analyze the economics of the proposals.
Okay. So have you received them?
Well, I think there's some other issues that I think Ms. Bennett is going to raise here.
Okay.
I would defer to her.
Okay, but you're maintaining your objection, is that correct?
Correct.
Ms. Hardy?
Well, I believe Ms. Bennett is going to explain. We have kind of a complicated situation here where BTA does object to this application, but there's an agreement between the parties relating to another case.
Okay.
So if Ms. Bennett would like to explain.
And I'll go to Ms. Bennett in just a moment, but you're maintaining your objection?
I believe that this case is going to be dismissed and that it's substituted with a case that is pending for another docket.
I see. Okay, all right. Ms. Bennett?
Thank you. Yes, this is a rather complicated situation. So as I mentioned, Mr. Bruce, this is a case where Texas Standard is seeking the division's approval of a state unit agreement. So it's not a pooling case like you've been accustomed to seeing. This is a slightly different situation. And under the division does have jurisdiction, I guess, to approve these types of agreements. The state exploratory unit agreement does contemplate OCD approval of these types of agreements, which is why operators come to the OCD for approval. And as I mentioned, Mr. Bruce filed this application and it did have a typo in it with respect to the section number. So I did file I filed a new application and it's under case number 25126.
25126. So
Yes.
it's a brand new application because of the typo.
Yes.
It can't be amended or adjusted. It just needs to have a whole new application.
There's not really a way to amend or adjust filed applications.
So you're going to file a dismissal for this case?
I will be filing a dismissal, but the reason I wanted to keep this case on the status conference docket for today is that BTA did file an objection to case number 25126, which is or will be hopefully now set for the February 13th docket. Texas Standard and BTA have reached an agreement in case number 25126, and BTA withdrew its objection. And that withdrawal of its objection is conditioned upon Texas Standard seeking a smaller unit than what was originally proposed in the application, which is what Texas Standard has agreed to do. So at the hearing, Texas Standard will be presenting exhibits and materials that show a smaller unit than what was proposed in the application, but that's due to this voluntary agreement that Texas Standard and BTA have now reached. And so my request would be that this case, the case 25126, be set for the February 13th docket, and that we be able to move forward by affidavit on that date.
Okay.
Assuming, of course, that there are no other objections to that case.
Great. Freya? Can you check to see if this case is on February 13th?
Yes.
And while she's checking, Ms. Bennett, when will you be filing your dismissal in 24985?
I'll file that today.
Okay. Are you sick, by the way?
I am.
Yeah, sorry.
Thank you.
Hope you get better quickly.
Thank you. One thing I wanted to add too is that, unfortunately, as I mentioned, under the division's process, there isn't really a way to amend an application, which is why we ended up filing a new application. But the State Land Office has already preliminarily approved the unit agreement, and is just the last hurdle now is the OCD approval. And then the State Land Office will be able to fully approve the unit agreement. And so Texas Standard's goal in going to hearing on the 13th is to keep the process moving so that the state minerals can be developed and so that they are not holding up development of that state unit. So they do have a strong desire in moving this forward on February 13th or as quickly as possible to meet their obligations to the state.
Well, the Division Hearing Bureau won't do anything to impede that goal. Freya, is it on the docket?
It's currently on the February 27th docket due to BTA's objection, but once I process the withdrawal, I'll move it back to the February 13th docket.
Perfect. And last thing, Ms. Bennett, you mentioned that a unit application is different than a CP application. What's it, in layman's terms, what's the difference?
Well, a unit application is, so when an operator wants to combine or consolidate state lands and state minerals into a unit, the operator goes to the State Land Office and proposes a unit agreement. And that agreement is essentially a voluntary agreement between the working interest owners to commit their acreage.
Okay. Well, you froze, Ms. Bennett, but I get the point. I understand a little bit about the difference. Okay, so is there anything else, Ms. Hardy?
No, thank you.
All right. Mr. Suazo?
No, Mr. Examiner.
All right. And Ms. Bennett, I'm assuming there's nothing else. If there is, we'll reopen the case, but I'm going to leave it here. We're in recess on this case. We will see you on the 13th of February for a hearing by affidavit in year 25126. Okay. Calling now number 14, 15, and 16. Case numbers 25035, 37, and 38. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Matador.
Good morning, Mr. Hearing Examiner Darren Savage on behalf of Cimarex Energy.
Cimarex, thank you.
Good morning, Mr. Examiner Miguel Suazo with Beatty and Wozniak on behalf of XTO Energy.
Okay, thank you, sir. Mr. Suazo, did you object to these cases?
We did. It's our understanding, however, that my client's been removed from the pooling, and I was just hoping that that could be confirmed on the record. Otherwise, no objection.
Okay, so you would withdraw your objection if that's confirmed?
Correct.
Ms. Vance?
That's correct. XTO has been dropped from the pooling.
So, Mr. Suazo, will you file a withdrawal?
Yes, Mr. Examiner.
All right. Mr. Savage?
Yes, we did object to these, and the parties are in fruitful negotiation. So we'd like to discuss what we might do next at this point.
Mr. Savage, how long do you, I mean, these are relatively new cases. How long do you expect negotiations to go on?
Well, Mr. Examiner, there's a lot of moving parts in this, but from talking to counsel and talking to my client, they really are engaged in this. So we think there'll be a positive outcome. What I think we would like is a status conference in February with the provision that we could have another status conference if necessary at a subsequent date.
We'll see. Ms. Vance?
That's correct. That is what Mr. Savage and I discussed. We were hoping that we could get one status conference, hoping that those would work out, and request that if we need to go to one more status conference, the division would let us.
We will look for you, Ms. Vance, to continue these cases to the February 27 docket for a status conference. And Mr. Savage, are you going to be tied up in the Empire Goodnight, or will you be able to attend the status conferences virtually?
I'll be able to attend.
Okay, great. Okay, I wanted to work this out today. Okay, then if there's anything else, Ms. Vance?
No.
All right, very good. We're off the record in these three cases. We're moving now to Permian resource cases. There are several of them that are linked together. 25039, 40, 41, 42. I'll stop there. Entry of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Permian.
Good morning, Darren Savage on behalf of Alpha Energy.
Alpha, thank you. I think those are the only two cases. Mr. Savage, you objected?
We did.
Okay, what's happening?
So in these cases, my client has a term assignment that is subject to expiration if the drills are not drilled, the wells are not drilled at a specific point. We don't, the good cause, as stated in the testimony, we feel that is not good cause in this case. So we would like to set a contested hearing date to address the good cause and other matters in the application.
Okay, Ms. Vance?
Yes, Mr. Hearing Examiner. Obviously, we would like to avoid that. We filed these as a precaution. The orders are set to expire, or the orders are set to expire in June. But we are hoping to drill these during that time. And as explained in the, this is the second extension. As explained in the first extension, we are still waiting for federal permitting. And so, we're a little bit at the mercy of the BLM. But if Alpha would like to set a contested hearing date, I'd like to confer with my client on some dates, but we feel like it's unnecessary at this point, and we'd like to continue to negotiate with them and try and work this out and meet those order deadlines. But yeah, if we can go ahead and plan, you can hold on just 1 second. I might have some feedback from my client. Yeah, if we could set this for a status conference in February. I know that they're asking for a contested hearing date, but would it be, we're hoping to set a status conference so I can confer with my client on a contested hearing date.
And Mr. Savage, if I set it for a contested hearing, what month would you like me to set it?
That's with the discretion of the OCD, but we would be open to, earlier, later. February would be fine. I think that, once the contested hearing date is set, the parties, have the opportunity to negotiate.
So Ms. Vance, I could set it for another status conference, but what I'd prefer to do is set it for a contested hearing on March 18. It'd be a limited contested hearing for a good cause only. That'd be the only issue that we hear. And if the parties negotiate out of that hearing and you're going to proceed by affidavit, just file a motion and we'll move it to another docket at your request. But I'm going to issue a pre-hearing order for the 18th of March. Please let me know if your witnesses are not available on the 18th of March. We'll find you something around that time.
That works. Thank you.
Yes, of course.
Mr. Hearing-Examiner, if I may add.
Yes.
Could if there's defects within the application, could we address those at the hearing in addition to good cause?
Yeah, we could. You could also file a motion in advance of that. But if it requires evidence to make a decision, it's easier to gather that evidence when we have sworn testimony and exhibits that are admitted into evidence to show that.
I think good cause is certainly the focus of this.
Yes.
But I think there's some other defects in here that would, at the hearing, we can inform the.
Okay,
thank you.
All right. All right, so we'll issue a pre-hearing order in these three cases for March 18. It will not be the first one on the docket right now. It'll be the second one on the docket, at least that I can see here. We have already set for Civitas and Chevron, I believe. Okay, that being said, is there anything else, Ms. Vance?
No.
Mr. Savage?
No, thank you.
Ms. Shaheen?
Before we move on to the next cases, I was going to ask you if we could go back to the two Fasken cases before I forget.
When you say the two Fasken cases, are you talking about the original cases I called?
Yes, the
Okay, let me go back.
249. Okay.
All right, we're in recess on 250, 40, 41, and 42. I am going to recall 249, 77, and 78, but I don't know that Ms. Luck is still with us. I see a KL on the screen. Did you discuss something with Ms. Luck?
I haven't discussed it with her today,
okay.
but it relates to the scheduling. You may recall that I had a conflict in the morning
I
on
do.
the
We're gonna do
28th.
2 o'clock, yes.
So, okay, I just wanted to clarify because I thought you wanted
I
us
did.
to go at 9 and I'm not available until.
Not a problem. We can call your case at 2 o'clock. Maybe what we'll do is we'll come back after lunch if we're still in hearing from the other cases, we'll take a break. We'll go in recess. We'll call your cases at 2 p.m. then.
Thank you.
All right. I'm glad you reminded me. Thank you. Okay. I guess, Ms. Luck, we don't need your participation, but would you let Ms. Luck know that we're not going to start on your cases until 2 o'clock?
Absolutely.
All right. Thank you. Okay. I'm now calling number 21, 2, and 3 on our docket. These are case numbers 25050, 51, and 52, Permian Resources.
Sharon Shaheen from the Santa Fe office of Spencer Fain on behalf of Permian Resources.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Apache.
Apache, thank you.
Good morning, Mr. Examiner. Carrie Hatley representing COG Operating.
Thank you.
Mr. Examiner, Jim Bruce representing Newbern Oil Company. I filed late, very late yesterday.
Okay, thank you. Do we have anyone else?
Good morning, Mr. Examiner. Jonathan Samaniego, representing American Energy Resources.
Good morning. Let's start with you, Mr. Samaniego, because you just came on the line. Did you file an objection?
I filed my my exhibits of ownership.
Okay, but I'm asking you if you filed an objection to a hearing by affidavit.
I have not. I can get that in today.
Okay, but are you on the record objecting to a hearing by affidavit in these 3 cases?
Yes, I'd like to make my oral response, and I'm objecting to the 3 cases.
Okay, so I expect that you'll file a document then through the portal with your entry of appearance and your notice of objection to the case moving forward by affidavit.
Yes.
Okay, Mr. Bruce, did you file an objection?
Yes, I did, Mr. Examiner.
On what basis?
Yesterday, yes.
No, Mr. Bruce, on what basis did you file an objection?
Mr. Examiner, I filed the objection about just before 5 yesterday, but I had an incorrect title, which Brea pointed out on the heading, so I refiled again before the hearing this morning.
Okay, but the question is, on what basis are you objecting?
Newbern, a couple of reasons. Newbern is in discussions with Permian, excuse me.
Can you repeat that?
Also-
Because hold on, Mr. Bruce. I need you to speak clearly because you're not here and the court reporter is not here, so we have to pick up what you're saying accurately. Would you start over again?
Yeah, sorry. Newbern recently received the applications. I think they were originally issued in the name of Federal Abstract Company because it was the original lessee of Newbern's interest. And so they got them kind of late, but also Newbern thinks it can work a deal with Permian.
Okay, I understand. And Ms. Hatley?
Mr. Examiner, we did file an objection. We are hoping to negotiate a JOA, but we're exchanging red lines and it's gotten a little bit complicated. So we would like to request another status conference in February, please.
Okay, perfect. Ms. Vance?
We are just monitoring at this time.
Okay, thank you. Before I go to you, Ms. Shaheen, let me go back to Mr. Samaniego. Ms. Samaniego, I know that you filed a document. I think I didn't review it, but why are you objecting to this case moving forward by affidavit?
I'm objecting because I was not notified. I'm an interest owner in the proposed pooling, and second, I am requesting evidence from a previous case, 24963, where Permian is claiming to have interests in many sections through the Santos interests. And I've presented evidence in 24963 that through the Santos merger, they do not own nothing but boreholes. So in 5 and 6, they don't own nothing but boreholes. That's part of the Santos interests. They have no right to pull. They have no right to move forward today.
Okay, thank you, Mr. Samiengo. Now, just to be clear, I didn't call that other case, so we're not really talking about that other case. We're just talking about these 3 cases, but I understand why you're objecting. I expect that you will file an entry of appearance as I instructed and a notice of objection through the portal. And now I'm going to go to Ms. Shaheen. These are your cases. How do you want to proceed?
Thank you, Mr. Examiner. I have conferred with Conoco and with Mr. Samaniego and with Ms. Vance, and we do not object to another status conference on February 27th. I would note for the record that I have been conferring with Mr. Samaniego. Permian has conducted a record title search and has found no indication that Mr. Samaniego or any of his entities have any interest here. So he did send me one document. It does not establish his interest. So we'll likely be filing a motion to dismiss his entry of appearance.
Okay. All right. So, Mr. Samiengo, the way this is going to work is after I get your entry of appearance and your notice of objection, Ms. Shaheen will have her landman do some research on your instrument of ownership. If they feel that it's not valid, they'll file a motion to strike your entry of appearance and objection. You will have time to respond to that with any evidence that you have, and we'll deal with that at the status conference as a motion hearing in a similar way that we're going to do today toward the end of our docket with another case that you've entered on with Mr. Holliday. So do you understand that?
Yeah. And if I may make one quick statement. Permian bought Santos for $175 million, and their landmen were fully unaware until I brought it up and brought it forth. Their own landmen did not know that they bought wellbores through that merger. $175 million mistake. That's truly individuals with more brains or with more money than brains. Their own landmen didn't know that, and they spent $175 million buying wellbores.
Okay, Mr. Samiengo, I understand.
Their landmen.
Ms. Samiengo, hold on. Ms. Samiengo, hold on now. I understand your perspective, and there have been errors made before by landmen. I think you've been involved in those cases, so you know that it's not an exact science. So we will deal with evidence at the time, and you'll be given a chance to present your evidence. The standard of evidence is a preponderance of evidence. So whoever has more relevant and reliable evidence will win in that motion hearing. So I've given you...
Brought forth, Permian has only brought forth hearsay. Hearsay is not admissible evidence. American has only brought forth burden of proof by documentation recorded at the Eddy County Clerk House.
Okay, thank you, Ms. Samiengo. I'm hoping you're not going to interrupt me again because then we will mute you. Hearsay, sir, let me finish. Hearsay evidence is admissible in an administrative hearing, and it's given the weight that I feel appropriate based on its reliability and relevancy. So please don't quote rules to me because you don't know what you're talking about. All right, let's move on now. We're going to have a status conference on these 3 cases, February 27, Ms. Shaheen. And is there anything more from you?
No, thank you, Mr.
All right,
Examiner.
very good. Okay, and please, Ms. Shaheen, if you file a motion to strike, please file it with enough time to give Mr. Samiengo time to have his landman do some research so that he can respond properly to your motion so that we can have a motion hearing on the 27th of February when we come back for a status conference.
And if I may make one more statement.
I just realized that I am going to be in the throes of the
Okay.
Empire Good Night
Right.
hearing. So the only other alternative would be the March status conference. Is that?
That's getting a little bit late. Let me think what else we might do. We have some special dockets that we could hear the status conference at the beginning of a special docket so that it doesn't cause a great delay. Freya, when do we have special dockets in February, around the 27th?
Leave it up right now. We have February 18th.
Okay, Ms. Shaheen, can you appear on February 18th?
I think so. Let me just double check real quick.
It can be virtual. You don't have to be here.
I'm getting close. That looks good.
Okay, so Ms. Shaheen, you'll continue your cases to the February 18th special docket as status conferences. And we may have a motion hearing that day, depending on your research and your motion and Mr. Semiengo's response. So let me go around the room now and make sure everyone is available. Ms. Vance, would you be available for a virtual status conference on these cases on the 18th?
It was March 18th, you said?
No,
Or February 18th? Yes.
Yes, that's a yes. Okay, very good. Ms. Hatley?
Yes.
That's a yes. Mr. Bruce?
Yes, sir.
Okay, very good. That's an affirmative answer?
Yes.
All right, very good. Mr. Semiengo, will you be available February 18th for a status conference / motion hearing?
Yes.
Oh, excellent. Okay.
And at that hearing, I'd also like for Permian Resources to present their evidence of ownership because the merger with Santos has been proven to be invalid. So they need to present new ownership interest that is separate from the Santos because that's invalid.
Okay, thank you, Mr. Semiengo. Okay, so Ms. Shaheen, we will see you on the 18th of February to accommodate your Empire Goodnight schedule. And we will hear that at now. Freya, are we starting at 9 a.m. on the 18th?
Yes, 9 a.m.
Should we do this at 8:30?
That's fine with me.
You okay with that?
Mhm.
Ms. Vance?
Fine with me.
Ms. Hatley?
Yes, sir.
Mr. Bruce, are you okay with 8:30 that morning?
Yes, sir.
I think you said yes. And Mr. Semiengo, will you be ready at 8:30 that morning?
Yes, sir.
Great. And if Mr. Semiengo, I just want to remind you, if you do have any witnesses that are going to testify on your behalf, please have them ready in front of a computer with a camera and a working microphone so we can swear them in and hear from them.
Yes, sir.
Okay, very good. Okay, we're off the record in these three cases. Thank you, everyone. We're moving now to number 24, 5, 6, and 7, Mewborn Oil. Case numbers 25055, 5657, and 59. Entry of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewborn.
Are there any other parties that you know of?
Hi.
Ms. Hatley.
Good morning, Mr. Examiner. Carrie Hatley on behalf of ConocoPhillips, but only in case 25059.
I see that here now. Thank you. Did you object in that case?
We did object, but
Okay.
we have since withdrawn our objection.
Okay. So then are you just monitoring?
Yes, we are now just monitoring.
Okay, very good. Is there someone else speaking?
Yes, good morning, Mr. Examiner, and hopefully this connection is better. I changed to my phone. This is Dina Bennett on behalf of Avant Operating.
Much better connection. Thank you. Okay, very good. So Ms. Bennett, did you object?
We did object, but I will be withdrawing our objection today and although retaining the entry of appearance to monitor and preserve rights.
Thank you. So Ms. Vance, do you want to move these cases to the next hearing by affidavit docket?
That's correct.
So February 13?
That works.
Works for us. Okay, so you'll move these, is it 4 cases? I think it's 4 cases, isn't it?
Yes,
Yes.
4 cases.
Okay, then we will see you on the 13th for a hearing by affidavit. Anything further, Ms. Bennett?
Nothing for me, thank you.
Ms. Hatley?
No, sir.
Okay, thank you. Ms. Vance?
Nope.
We're off the record in these 4 cases. We're now moving to number 28 on our docket. This is Raz Oil and Gas 25081.
Good morning, Mr. Examiner. Dina Bennett on behalf of RAS Oil and Gas.
Thank you. I don't see what are you requesting the division? It's blank here, what you're asking.
So what RAS is seeking, this is a saltwater disposal well, an injection well, and RAS has an approved order to inject into one formation and is requesting approval from the division to inject into a different formation.
When you say different, do you mean in addition to the approved formation or just a whole different one?
In lieu of the approved formation. So right now, RAS is authorized to inject produced water into the Devonian formation, which is a very deep formation. And RAS is seeking approval to plug the well up to a higher injection interval,
Into what formation?
the Delaware Mountain Group.
Delaware Mountain Group. Okay. Are there any other parties that have entered an appearance in this case?
Yes,
Morning, Mr.
Mewborn.
Examiner. Adam Rankin with the Senate Office Hall in Hart, appearing on behalf of Mewborn Oil Company.
Thank you. Did you object?
We did,
On what basis?
on the basis that we have offsetting plans for offsetting development below, and have concerns about impairment between the different zones. So they'll be injecting into the Delaware Mountain Group, and Mewborn is intending to develop offsetting zones in the vertically offset. They're worried about.
Mr. Rankin, I hate to ask you to repeat everything you just said, but
Yeah.
you're so far from the microphone.
Sorry.
I can't even hear what you're saying
Oh, yes.
clearly.
Sorry.
So why did you object?
Mewborn has plans to develop offsetting, vertically offsetting acreage tracts, and they're concerned about impacts from the disposal into their planned development.
So Mewborn fears that this request to inject into a different formation will impair your clients' existing operations or future operations?
Very soon planned operations. They're lessees in the acreage, and they're concerned about impacts.
I see. Okay. All right. And Ms. Bennett, did you hear that?
I did, and Mr. Rankin and I have been in communication about this issue, and I believe that we have an agreement in principle to address Mewborn's concerns, and that way Mewborn would be able to withdraw its objection. And just for one more bit of context on this case, this case was originally set for January 9th, or that's the date that was in the application. And this case was then part of the set of cases that was automatically or would have been automatically set for February 13th, but for Mewborn's objection because the January 9th docket was so full.
Okay.
So here, what I'm hoping is that Mr. Rankin and I will be able to reach an agreement today, hopefully, to withdraw Mewborn's objection so that this case can be set back on the February 13th docket as originally contemplated.
Thank you. Mr. Rankin?
Mr. Examiner, yes, we have reached an agreement in principle. We need to just paper it up. So I don't know how long that will take, but as soon as it's done and my client's satisfied with the written terms and agreement, then we'll withdraw our objection, assuming that we're able to come to that. I expect we will. And we're already working on the paperwork, so we're hopeful that we can get that done quickly.
Okay, thank you, Mr. Rankin. So Ms. Bennett, it'll be up to you to move the case to the February 13 docket for hearing by affidavit. I think you can do it now in hopes that the objection will be withdrawn. And I suspect if it's not, then you'll have to move it to the next docket, February 27, for another status conference.
That would be great. I think the division's notice for the February 13th docket might be going out today or tomorrow. So if it's possible to have it on the February 13th OCD docket notice. And then, of course, if we're unable to get the objection withdrawn, then of course it wouldn't go on February 13th. But there's a bit of a timing constraint here given the deadline for the OCD docket notice to go out.
Just one, I mean, obviously, it's completely within your power to put it on the February 13 docket. As of now, you could move it, right?
Well, I don't know that I can because of Mewborn's objection. But if I can, then yes, I will do that. I will file whatever it takes to put it on the February 13th docket. I can file a motion to
Right.
continue to the February 13th docket today.
Right. But
Um,
the other part of what you said that I wasn't quite clear on is if did the division not, didn't the division already notice this case for the January 9,
that's
you
right.
said? Okay.
That's right. I apologize. I forgot. This one
Okay.
was already noticed for January 9.
Right.
So if I file a continuance to the February 13th docket, I think I'm good there.
I think so
Thank you.
too.
Sorry about that.
Yeah, no, I understand. Anything further, Ms. Bennett, on this case?
No, thank you.
Mr. Rankin?
Nothing further.
Okay,
Thank you.
We're in recess on this case. Let's go to number
Thank you.
29 through, it looks like 36. These are all Permian resource cases. I'll read them all. They're joined for the purposes of a hearing. This is 25093, 94, 95, 96, 97, 98, 99, and 25100. Entries of appearance, please.
Dana Hardy on behalf of Permian Resources Operating.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of Matador.
Terrence Savage on behalf of Cimarex Energy.
And are those the only parties, Ms. Hardy?
They are.
Okay, very good. Who objected that you know of?
Matador has objected.
Okay, so not Cimarex, but just Matador.
That's my understanding, correct?
Perfect. Ms. Vance, why did you object?
It's so we filed competing cases and we just filed those and got the case numbers. However, that being said, it's my understanding that the parties are in negotiation. So we would like to ask for a status conference if Permian and Cimarex are agreeable to that. But as of right now, we did file competing cases.
And do you, when you say you filed them, do you have numbers for them yet?
Yes, I do.
What are the numbers?
Give me one moment. So it is 25169 through 25180. Sorry, wanted to make sure that they were all in order. So that's 25169 to 25180.
So there's 11 or 12 cases?
Yes, that sounds right. 11 cases.
Okay.
Yeah.
All right. Ms. Hardy?
Mr. Examiner, there are a lot of moving parts in these cases. I think, and this is a refiled version of these applications. They were previously dismissed and refiled. I think Permian Resources would prefer to set them on a contested hearing docket in a time frame around late April, which I think would give the parties time to negotiate.
You have the 29th of April.
I believe that would be fine.
Okay. Ms. Vance, I know you haven't spoken with your client yet, but I'll set these for April 29 contested hearing. It gives you the parties plenty of time to negotiate, to confirm your witness availability. If that doesn't work, we can always do the 15th of April. Ms. Hardy?
I can confirm with my client.
Sure.
Yeah.
But those are those.
Okay.
So that's what we'll do. And I'll of course include your cases, Ms. Vance, on that pre-hearing order.
Okay, that works for us.
Okay, very good. So 4/29, 9 a.m. start time. Good luck with your negotiations. Anything further, Ms. Hardy?
No, thank you.
Ms. Vance?
No.
Mr. Savage?
No, thanks.
All right, very good. And Ms. Savage, you're just going to be monitoring?
At this time, correct.
This time. KG, thank you. All right, let's go now to a motion hearing we're having. This is with Mr. Holliday and Mr. Semenyengo. This is number 37 on our docket, 24517. Before actually we get to there, we do have on our docket case numbers 25115 and 25117. Mr. Savage, do you represent VF Petroleum in these cases?
I do, and we filed a continuance
You did? Okay.
early yesterday morning. So I guess it hasn't been gone to the system yet.
Okay, perfect. So then we don't need to call these cases because they're going to be heard next Tuesday.
That's correct.
Along with the other cases.
Yes, sir.
Okay, very good. Okay, going back to 24517, entries of appearance, please.
Good morning, Mr. Examiner. Ben Holliday on behalf of Silverback Operating 2.
Thank you. Mr. Samiengo, I'm waiting for you.
I just had to unmute. I was muted for some reason.
Okay.
Jonathan Samaniego, representing American Energy Resources.
Okay, perfect. So so here's how we'll do this. First, I'm going to just give a little context to what we're doing here today. We have a motion to reopen the case filed by American Energy Resources. The case number is 25417. We issued an order number R23045. Mr. Samaniego claims that he has an interest in the unit, and he has filed a document to demonstrate that ownership interest. He claims also that he should have been given notice, but that he was not given notice. We then have a response to the motion filed by Mr. Holliday. This was filed, let's see when this was filed. This was filed only a few days ago on the 21st of January. Today is the 23rd of January. All right. And I do see the evidence that was supplied by the landman in this case on behalf of Silverback. Mr. Samaniego, did you have a chance to review the response?
Yes.
Okay, very good. Now, I understand that you just got this 2 days ago. And I want to give you time to file a reply to this. But the reply would have to include evidence to be considered. Do you understand?
Going off of the last hearing we just had under 250, 50, 51, and 52, you stated that even though with no evidence, hearsay is admissible. Okay, and I'm not saying that my evidence is hearsay. I'm going to pull exactly those same books and pages at the Eddy County Clerk's office and get them to you. But I'm not going to rush down to Carlsbad 2.5 hours away, going 100 miles an hour, risking mine and everyone's life on the road. Okay, I need adequate time, and I didn't get that filing until 5 o'clock on the 21st. I really had less than 24 hours.
That's why I'm giving you more time to reply. So, Mr. Holliday, you've provided evidence in support of your motion and you've made, or your response, excuse me, and you've made legal arguments as to why I should dismiss the motion to reopen this case. So, Mr. Samiengo, I want to be clear with you what I'm looking from you, okay? I'm expecting that you're going to file a reply. I'm going to give you a deadline. I am expecting that you're going to attach evidence in support of your reply. And I am also expecting that you are going to have either an expert witness, like a landman, or someone explain to me why your evidence what's the word I'm looking for? Not counteracts, but goes against. I can't think of the word I want. Mr. Holliday, what's the word I want?
He needs to come in and establish a valid chain of title that would entitle him to notice under the compulsory pooling statute.
Yes, exactly. Now, Mr. Samiengo, do you understand that?
I do, but I'm requesting that Silverback be held to the same standard and also present their chain of title to show their interest in the pooling.
Mr. Samiengo, I'm not going to comment on.
Everybody they
Mr.
notified is
Samaniego,
not an
I'm not
interest
going to
owner.
comment. Ms. Samaniego, don't speak over me or I'll have to mute you. I'm not going to comment on that request that you just made. Everything needs to be filed properly through the portal. At this point in the proceedings, we're basically in the middle of a motion hearing. So you have filed a document to support your motion to reopen. I've considered that document. I have instructed Mr. Holliday to have his landman research your document and provide a response. He has done so. His claim, very simply, is that your document does not establish ownership for two different reasons. And I'm not going to go through them. You can read the response yourself. If you have no further evidence, I'm going to rule in his favor and deny your motion. However, I'm going to give you an opportunity to file a reply and to show me why your document does establish ownership in this and why you were required notice under the original case, because that's the only reason you could reopen the case. So I hope I've explained myself clearly.
Notice under the case. I'm writing all this down. I'm sorry.
This is a little bit like a ping pong game, Mr. Samaniego. You filed you hit the ball across the net the first time. Okay, you filed a document with some evidence, so it needs to be considered, and you need to be given a fair hearing on that, and that's what we're doing. Mr. Holliday and his client hit the ball back. Okay, they provided evidence and legal reasoning why your document does not do what you think it does. Okay, now it's your opportunity to hit the ball back across the net. This is your final opportunity.
So what you're requesting is that the books and pages that were listed on the response, you want those books and pages as the exhibits to state Americans' standing.
Okay, Mr. Holliday, how would you respond to that? Because I'm not going to respond to that. How would you respond to that?
I would just revert back to my prior understanding of the case is that put me in a bit of an awkward spot. But if I were on the other side of this, I would need to bring forward evidence of a chain of title that would have established me to notice.
Okay, but that's not what I was asking you, but thank you for clarifying that, because I think that's what Mr. Samaniego needs to do here. But the reason that, so just give us a summation of your response. Why does that document that he has so far provided fall short of what you just said?
Sure. Okay. Thank you. There's two reasons really quickly. One, there was a 2010 quiet title suit that eliminated the claims and the chain of title under which American Energy claims, and it's Silverback's position that they don't own an interest. Even if they did own an interest prior to the quiet title suit, prior to all the deeds referenced in this, the original owner of those leases that we're talking about executed a JOA. That's in 1978, and the 1978 JOA, under that, Silverback 2 is the operator. So all the parties that are subject to the JOA are not subject to the compulsory pooling order. They're not required to notice. That's all handled contractually.
Right. So, okay. So, Mr. Holliday, thank you for explaining that in clear language to Mr. Samaniego. So, Ms. Samaniego, if you read the response, you will see what Mr. Holliday just said, but he explained it to you very, very clearly in language that I think is understandable by non-lawyers. So, basically, if you want me to rule in your favor and reopen this hearing on the original case 24517, upon which the division has already issued an order, you need to show me why what he's saying is not correct. In other words, he's saying that there was a quiet title suit in 2010, and that quiet title resolved the ownership interest at stake here. That's number one. And he's saying that even if it didn't, the interest that you're claiming was incorporated in a JOA back from 1978. And so you were not an uncommitted interest at the time of this case going forward, and that's why you didn't get notice. So those are the two issues you need to address, and you need to address them not only verbally, but you need to show me evidence as why those two issues should be resolved in your favor and not in favor of Silverback.
Yes, sir. And if I can make a verbal oral a response to that quiet title. I am going to get these books and pages to you. But as far as the quiet title was 10 years after Wildcat retained interests. Wildcat was not mentioned in the quiet title, therefore under the color of law, if it's not mentioned in the quiet title, therefore the interests were not quiet titled in the quiet title. Wildcat purchased many interests 10 years prior, therefore interests do remain in Wildcat and were assigned to American.
Okay, Mr. Samiengo, thank you for telling me that. Let me just explain one other thing. The division is not the place to adjudicate interest ownership. That's not what we do here. That's a court's decision to make. So if in fact you have a claim about the quiet title or even the JOA, that would be a suit in the Fifth Judicial Circuit.
There would be a claim if I was listed and so on and so on, but Wildcat was not listed. Therefore, they were not a participant or a party or defendant in the quiet title. That's the color of law. That's the color of law. You cannot be. That's the color of law.
Yes, sir. You've said that 3 times now. I heard you the first time. So let me just finish this by saying I'm giving you an opportunity to reply, and then we'll come back for the rest of this motion hearing, and we'll set that date in just a moment. But if you want to effectually respond or reply to this response, you're going to show me why those 2 arguments are not correct, why the quiet title suit, why that argument does not apply, and you'll need evidence to support that, and you'll need to explain why the JOA argument also does not apply to you, and you'll need evidence to show me that as well, not just argument, but evidence as well. How much time do you need to reply?
I'll be ready, I guess, at the February 18th.
Well, then, okay, so we're not adding it to February 18, so let's slow down here. The next time we have time to hear this case would be February 13. Mr. Holliday, would you be prepared to have a motion hearing on the 13th of February?
I believe so. Let me just make sure I'm not committed to something that day.
Okay.
But that does give me plenty of time.
Right.
And also, I went on the record that Silverback is claiming ownership through the quiet title in the chaplain lease, but all the people they notified were no interest owners in the chaplain lease. The people that they notified don't own the interest in the chaplain lease at all. Go ahead.
Mr. Samiengo, this argument isn't helping you right now. I've told you exactly what you need to do, and I'm not your attorney, so please understand that my telling you that is from my perspective here, okay?
No, I know. I just want my statement on the record that Silverback is stating these interest owners that they notified, they're presenting a quiet title claim that these are now all the interest owners in the chaplain lease, but yet on their notification, they never notified any of those quiet titles that were awarded the interests. That's kind of funny. That's kind of weird.
Mr. Samiengo, this argument doesn't help you because you don't have standing to argue for other parties. You have only standing.
I'm not arguing for nobody. I'm pointing out what
can you mute? Would you mute the microphone, please? Mr. Samiengo, if you speak over me, we're going to mute you. So it's really not in your benefit to do that. I've told you what you need to do. I'm not going to say it again. Hopefully you've written it down. So Mr. Holliday, is February 13 work for you for a motion hearing?
Yes, sir.
Okay, very good. Mr. Samiengo, I'm going to give you a deadline. So give me a minute here. Let me get my calendar here in front of me. Today is the 23rd. I'm going to give you until the 5th of February to file your reply and the evidence in support of your reply. That will give Mr. Holliday a few days with his landman before the 13th. Mr. Holliday, I'm not going to give you any more, your response is your document here, but you'll certainly have an opportunity to present whatever witnesses you want to at the February 13th motion hearing. You can present any evidence at the February 13th motion hearing as well, as long as you share it with Mr. Samanyengo before that date. Okay?
Yes, sir.
All right, so we're going to put that last because we have a list of hearings by affidavit that we're going to be dealing with that day. So, Mr. Samanyengo, we probably won't get to this case until about noon. So I'm letting you know if you have a witness that you should advise your witness to be available later morning, early afternoon. Virtually is fine. And Freya, would you add this? Actually, it's not up to Freya to add. Mr. Holliday, would you please continue this case to the February 13th docket for a motion hearing?
Yes, sir, will do.
Okay, is there anything else, Mr. Holliday?
Nothing from Silverback. No, sir.
Okay, very good. Well, Mr. Samanyengo, unfortunately, when you force me to mute you, I can't ask you if there's anything else, but I'm going to assume there's nothing else. I've explained what you need to do at this point, and we will see you then. And you have a deadline, so I expect that you'll keep the deadline of the 5th of February for any document that you file in support of your motion. Okay, we are off the record in this case, and I believe we are done for the day. So thank you, Mr. Holliday, Mr. Samanyengo, and Mr. Cogswell. I hope you feel better. We're off the record. Thank you.
No, it is,